Good morning, Your Honor.
Check.
Terrell Crawford representing Mr. Scott.
Terrell Scott.
All right, does he stand mute, wait formal reading on both of these?
He does, Your Honor.
Now, as I understand, he's going to plead on 530, and they're going to go ahead and dismiss 26W843-417. So they're going to dismiss the June 13th incident of trespass. He's going to plead to the June 21 incident of trespass. True?
True, Your Honor.
Is that what you want to do, sir?
Yes, sir.
If you plead guilty here to this offense, you could get 90 days, fines 500, costs are all those. Do you understand that?
Yes, sir.
Hold on. This is one of the most important moments in any criminal case. Before a judge accepts a guilty plea, they must make sure the defendant understands every constitutional right they're giving up. No jury, no witnesses, no trial. Once that plea is accepted, there's no pressing the rewind button. Question for you. If you were facing charges, would you fight your case at trial or accept a plea deal to avoid the risk?
Understand all your rights. Again, you're presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to a trial by court or jury. You have the right to question their witnesses, to bring in your own, to use the subpoena powers of the court to bring in those witnesses, and you have the right to cross-examine those witnesses. You understand that?
Yes, sir.
All right. If you plead guilty, you understand we're not going to have a trial.
Yes, sir.
The charge trespassing, how do you plead?
Guilty.
June 21, 26 at 8:54 p.m. We at 25338 Oxford Street, City of Woodhaven, County of Woodhaven.
Yes, sir.
That you've been trespassed in the past from that place, told not to appear there. Told not to appear there by the victim who evicted you, by the police, and by the court.
Yes, sir.
Anybody forced you to plead guilty?
No, sir.
Plea is accepted to that charge. That was subsequent to these other dates, right? That's why they wrote the stalking. I'll accept that plea on file 26W 843-417. Sorry. I will dismiss 26W 842-66. You got 496 on here.
496.
496 is the stalking, Your Honor.
And then there's three.
Yeah.
Did you catch that? Even the judge admits the timeline is getting confusing. With multiple trespass incidents, dismissed charges, and a separate stalking case, keeping everything straight becomes critical because one mistake in the record can affect the outcome. It's a reminder that courtroom proceedings aren't always as smooth as TV makes them look. They're often messy, and precision matters.
Okay. He's trespassed so many times, he's got me confused. So I took his plea on the June 21 incident date. Is that true?
Yes.
And they dismissed June 25 incident. Is that true?
Yes.
The trespass on that, right?
Correct.
I'm sorry, the June 13th. My apologies. They're dismissing the June 13th incident. He's pleading on the June 21 incident.
Yes.
And they also are dismissing the April 26th incident, but he's also pled on the stalking charge, right? All that's
Yes.
correct?
Yes, that sounds right.
So he didn't go back there after I ordered the bond on any of these, did he?
Right.
Been incarcerated ever since.
Right. Right. Personal bond on that 530, $1,000. I've already got enough orders for him. We'll set the sentencing date on the same day as the stalking, Heather. So that will be on what day again? July 13th at 1, right? I'm sorry, I intertwined a register here. This is a mess. Sentence him on the other trespass that I just took the plea on July 13th at 1. Am I right, Heather?
Judge, I was notified that it looks like Mr. Crawford won't be here that day. He will be here on July 14th. If we could do that in the PM.
Sure. July 14th at 1. July 14th at 1. Okay? And we're gonna, so they're gonna have to meet within probation on the on the pre-sentence report on the stalking charge. I'm not ordering one on 530. Okay? So just make sure that they know that he has to meet with probation and probation knows. Thank you very much.
Thank you, Your Honor.
Alexis LeFay Harris, 26I261014.
Now here's a behind-the-scenes courtroom moment that most people overlook. The judge is frustrated because the required advice of rights forms weren't signed before the hearing. It might sound like paperwork, but it's actually a safeguard to prove the defendant understood their legal rights before entering a plea. Would you trust a guilty plea if those protections weren't followed properly? Let me know below.
I gotta have these guys have them sign the advice of rights. I don't know how many times I gotta ask. You may not. You're presumed innocent. They have to prove you guilty. Would you please do me a favor? Would you rate the prosecutors and tell them that? I talked to some of them. I'm still getting half of these on pretrial dates without signed advice of rights. If you plead guilty here, you're.
The backside, is that what you're talking about?
Yeah. You're presumed innocent. If you plead guilty, you're giving up your right to a trial. You're waiving the requirement that they prove you guilty beyond a reasonable doubt. You're waiving your right at the trial to cross-examine their witnesses, to use the subpoena powers of the court to bring in those witnesses. The testifier remains silent. If you remain silent, that silence would not be held against you. If you plead guilty, you're giving up all those rights, including your constitutional right to a trial by jury. Do you understand?
Yes.
To the charge, and you have the right to a lawyer. I'll still give you a lawyer if you want. Would you like an attorney, court-appointed attorney to represent you? To the charge of malicious destruction of property, how do you plead?
Yes.
We're on March the 4th of 26. Were you in the township of Grosse Ile?
Yeah.
And specifically, where were you?
Pardon me, 10045 Road.
Sorry, say that again.
My old apartment, 10045 Road.
And what did you do there?
I slapped the phone out of my ex-wife's country.
Okay. Well, did you damage the property? Was the cell phone?
I don't know.
Slow down.
Notice how the judge suddenly slows everything down. That's not hesitation, it's careful legal work. The defendant says she isn't sure the phone was actually damaged, and that's a huge issue because malicious destruction of property requires actual damage. The judge isn't trying to convict anyone. He's making sure the facts actually support the charge before accepting a guilty plea.
Was the cell phone damaged when you knocked the phone out of her hand?
I don't know if it was damaged before.
Now you're pleading the destruction of property.
Because I know I smacked it out of her.
All right, but how do you know it was damaged? If it wasn't damaged, you could have been charged with assault or something else.
She said I broke the screen on.
Any reason to dispute that?
I don't want to dispute it.
Ma'am, if you don't know if you damaged the phone, then don't plead guilty. This is malicious destruction of property. That means you had to intentionally damage property. Doesn't mean that you might not have been guilty of assault or assault and battery, but there was no damage to the phone. There was no destruction of property. Do you believe the way you struck the phone, when you hit the phone, that you damaged the phone?
I hit the concrete, so yeah, I'd say it broke.
And was it a strong, slap of her phone that you were utilizing just to intentionally knock the phone out of her hand?
Yeah, she was trying to take a picture of my license plate.
And are you on probation or parole?
I know.
For what?
I really lied.
Were you on probation on March the 4th of 26? Anybody force you to plead guilty? Were you under the influence of anything at the time this occurred?
No, sir.
I'll accept the plea. Take it under 771.1. I'm gonna order a pre-sentence report. We're gonna give you a sentence date and you can come back on that date. That date will be
July 15th at 8:45.
July 15th at 8:45. Okay? So you're gonna go over down the hall and get your notice. And then you're going over to probation where you'll be interviewed and then you'll come back for sentencing on that date, okay?
Yes, sir.
Thank you very much. Have a great day. I do not, John.
Okay, thought it was asking.
Thank you. Leanne Nicole Joseph. 2